There are some common misconceptions that I have to talk to people about all the time having to do with contracts. One of the most common misconceptions that I see is people don't realize that the miscellaneous provisions at the end of a contract actually are important and mean something. Some of these clauses include a merger clause, and that says something to the effect that this is the entire agreement, supersedes all prior agreements, and incorporates by reference all communications regarding the subject matter. What that does is make sure that somebody can't say, well, you and I spoke about this additional term or this additional burden that you have accepted, even though it's not in the contract, and make sure that the contract itself is all the evidence you need of what the terms are in the contract. Another part of this typical boilerplate language is about how if you don't enforce your rights every time, you don't waive your rights in the long term. And that language comes from an antique case where somebody wasn't enforcing their rights and suddenly did, and the court said, well, if you didn't enforce it one time, then guess what? You've waived the right. So now we always put that in the boilerplate language in a contract. Now, I'm using the word boilerplate, but a lot of people have never heard that before. And what it means is in the olden days of printing presses, when we would write contracts, we would have a basic form that the printing press would stamp out. And that is the boilerplate language that you see at the end of a contract that might be called miscellaneous or something like that. And it's not dealing with the essential terms of the contract, like the price or the people who are involved or the services or goods that are being sold. So for those reasons, the boilerplate language at the end of a contract that people commonly think doesn't really matter, really matters.